The central player in the criminal justice system is a prosecutor. Prosecutors decide what cases are brought, what charges are filed against the accused, what plea bargains are offered, what sentences are imposed very often, or at least have a tremendous amount of power in deciding that. So today I want to talk about the discretion that prosecutors have and how it's exercised and how it has an impact, particularly in capital cases, because as we'll see, the two most important decisions in any capital case is often made by just one person, and that's the prosecutor, called United States attorneys in the federal system, called states attorneys or district attorneys, usually in the state system. Prosecutors have all sorts of discretion in terms of where cases go, what cases are brought, and so forth. The first, what to investigate. How are resources, law enforcement resources, the prosecutor's office's resources, how are they going to be allocated? Of course, the prosecutor is always going to be prosecuting, all prosecutors' offices are going to be prosecuting violent crime, murders and robberies and other crimes against people and crimes where there's damage and so forth. But there's a lot of discretion in terms of how much emphasis might be put on economic crimes as opposed to, or public corruption, or other areas like that. Does the prosecutor look at financial, business misdealings that might be a basis for prosecution? Does the police send people out to restrooms to try to find people looking for sexual partners, or do they try to find people looking for prostitutes, or do they try to find people looking to buy and sell drugs? And if they're looking for people to buy and sell drugs, do they dispatch those officers to college campuses to look for drug use there, or do they send them to certain parts of town? All of these things are going to influence which cases come into the system eventually. And so the investigation is critical in terms of what kinds. Of course, in death penalty cases, those cases are going to be investigated and prosecuted, but the overall power of prosecutors in that regard is worth noting. The next thing is whether to charge a case or not. When some cases come into court, let's say the quality of life cases that you have in some cities now. People are arrested for loitering, for small amounts of marijuana, for jaywalking. Are we going to bring charges against those people? Are we going to bring them before a judge, try to get a sentence, or might the prosecutor decline prosecution in those situations? And those can be in more serious cases as well. A person's arrested for assault. The question may be, did they act in self-defense? The prosecutor will study the case, make a determination, and perhaps decide not to prosecute. The Strauss-Kahn case, where Strauss-Kahn was charged with rape, sexual assault, but eventually the prosecutor's office in Manhattan decided to decline that prosecution and not to go forward. So this is a tremendous power that the prosecution has in terms of whether to charge at all, even though there may be a basis for thinking there's a charge there. And then what to charge. The same behavior can often be prosecuted under a lot of different statutes or laws. Assault may be prosecuted, for example, as aggravated assault, which might be a felony, that is a crime punishable by over a year, and it might carry 10 years, say, just in some jurisdiction. The prosecutor could charge that same crime as simple assault, punishable by only 1 year. So right there in making that charging decision, in charging the more serious crime or the less serious crime, the prosecutor's deciding right there what the range of punishments are going to be. In one case, it's going to be 10 years. In one case, it's going to be just 1 year. In the readings, we have that in Manhattan, auto stripping is charged as a felony. So it's more seriously punished. In Brooklyn, it's charged as a misdemeanor. So we have different prosecutors' offices with different approaches to the same behavior, but charging different things. So again, this is an area of prosecutorial discretion. When to charge. The case that we'll take up later of a fellow named Harrison Connick. The government spent 4.5 years putting together this elaborate case against him, which involved a check kiting scheme. They finally charged him with it, assigned a real estate lawyer to represent him, and then told him to be ready for trial in 25 days, and they tried the case in 25 days. So obviously the prosecution, if it does something like that, can get an enormous advantage in taking time to build a case. There's really no limit. A lot of times when prosecutors are investigating cases, one method they use is a grand jury, that people can be subpoenaed to go before the grand jury, which is only the prosecution, the witnesses. There's no defense lawyer present there. There's no judge present. And grand jury investigations may go on for years before charges are brought. Where to charge? This can be very important, has been in drug cases, whether those cases are charged in federal court or whether they're charged in state court. Most of those cases can be charged in either one, particularly with regard to cocaine, crack cocaine. You can charge it in state or federal court, same thing for powdered cocaine. And there was a lot of controversy about where those charges were brought because they were often brought in the jurisdiction that carried the heavier sentence. We see that in death penalty cases. For example, if a potential capital case is in Orleans Parish, say New Orleans, Louisiana. Orleans Parish is about 70% African American. So the jury is going to reflect that. There's going to be a very large number of African Americans probably in the jury pool and that will make it onto the jury. But if the case is prosecuted in federal court, it will be prosecuted in the Eastern District of Louisiana, which includes not only Orleans Parish, but all the parishes around it. In fact, a very large part of the state of Louisiana. And the jury, the percentage of African Americans in that pool is only 20%. So by deciding where the case is brought, the state's attorney and the United States attorney can decide whether it's going to be brought in a place where the citizens are black citizens are 70% of the population, or where they're 20% of the population. The same thing happens in Prince George's County, Maryland. These cases are often brought in federal court in Maryland. Same thing around St. Louis or in St. Louis. Those would not be the places where you would think there would be the greatest number of federal death penalty prosecutions, but it turns out that it is. And then, as I said, in state or federal court, one other point to make is whether they're brought in juvenile court or adult court. It used to be that any child, anybody under 18, could only be prosecuted in adult court if there was some showing made by a judge, made before a judge, and a judge certified the case to adult court. Many jurisdictions today, the prosecutor decides. The children presumptively can be charged as adults, and the prosecutor can waive prosecution and they're prosecuted in juvenile court. This is a classic example of how much power has moved from the judges to the prosecutors in terms of where cases are prosecuted, in terms of what sentencing is available for people. It's a power that I think many people may not realize is being exercised by prosecutors in these cases. Just to speak for a moment about the investigation that prosecutors do, which I've alluded to, obviously, let's talk about state prosecutors, because I said most of these cases are going to be in the state courts. 95% of criminal cases are state prosecutions, and most death penalty sentences have been imposed in the state courts. But a state prosecutor, a district attorney, state's attorney will have all the law enforcement agencies, the State Bureau of Investigation, the local police departments, the sheriff's departments, all of the law enforcement agencies that are available. Of course, that's what their job is to go out and investigate crimes, take statements from witnesses, and so forth. The states also have crime laboratories now. Unfortunately, a lot of the crime laboratories are part of the law enforcement agencies. The National Academy of Science has suggested that perhaps the integrity of some of the science has been compromised a bit because it's not seen as science as much as it's seen as law enforcement sometime. But at any rate, when the prosecutor needs to have evidence analyzed, fingerprints, DNA testing, which of course is so critical today, but all sorts of things, the blood spatter analysis and so forth, it has people on staff already to do those things. And then of course prosecutors usually have a staff as well. Worth mentioning is the fact that a prosecutor has a power that no other person in the legal system has. And that's the power to reward people who cooperate and say give them favorable testimony for their case, and punish people who do not. We see this in cases where several people are charged with a crime. Very often one will agree to testify against the others in exchange for having the charges dismissed or having the charges greatly reduced. But for example, Sammy the Bull Gravano, even though he committed 19 murders, was allowed to plead guilty and get only 5 years in exchange for his testimony against mafia boss John Gotti in the 1990s. That's the kind of reward that the prosecution can give a witness who cooperates. If the prosecution doesn't get what it wants, it can often make life pretty difficult for a person. It can investigate their taxes and just about everything about them. When Webster Hubbell did not give testimony that the Ken Starr wanted against Bill Clinton, Starr actually indicted Webster Hubbell's wife as a way of bringing more pressure on Webster Hubbell. So there's a tremendous amount of pressure that often is brought upon people to get them to cooperate. If some person is in custody, where are they housed? Are they housed in a part of the jail where they're scared to death and something could happen to them, or are they given some better arrangement than that? Or are they released pending trial, depending upon what their bargain with the prosecutor may be. And then what penalty to seek. The prosecutor can influence as we said earlier, by the charging decision. If something is brought, may carry a sentence of 10 years, then it's going to be obviously a larger sentence than if it's charged as something that only carries 1 year. But in addition to that, prosecutors can enhance sentences by repeat offender papers. This just means the prosecutor files a paper that says this person has 2 prior convictions, for example. And if they're convicted of this, it'll be the 3rd time, 3 strikes, you're out. So they get a life sentence instead of the sentence that they would normally get for that crime. This can be huge if the person is charged with a crime that might only carry a fairly small sentence otherwise. Mandatory minimum sentences. Most legislatures now have passed mandatory minimums. So for example, if a prosecutor charges someone with armed robbery in a state, the person may have to do at least 10 years before they're eligible for parole. The prosecutor can take that away by just charging robbery and taking away the armed robbery part of it, and then the 10 years is no longer there. This will be a subject for plea bargaining, which we'll talk about in a moment. The one we're most concerned about, the notice to seek the death penalty. A prosecutor never is required to seek the death penalty. In any state, in any jurisdiction in this country, it's always discretionary with the prosecutor. Some prosecutors don't ever seek the death penalty, even in states that have it. And some prosecutors seek the death penalty very frequently. But this is one of the 2 most important decisions that are made in capital cases, because very often the prosecutor won't decide or won't notice up the death penalty at all, and the case will never be treated as a capital case, even though it may be a murder case and even though it may involve fairly aggravated murder. That first decision, when Robert Morgenthau was the district attorney in New York during the time that New York had the death penalty, about 10 years, he never sought the death penalty in any case. Neither did Robert Johnson, the prosecutor in the Bronx. Both of them had, they just didn't feel like the death penalty was useful, and so they didn't bring it. On the other hand, if you go to a place like Houston, Texas, prosecutors bring the death penalty quite frequently. And then finally, the prosecution can also, particularly in the federal system, reduce the sentence. Again, for someone cooperating, they can note that the person provided substantial assistance to the government, and that can reduce the sentence that the person serves. So that's another incentive for people to agree to cooperate with the government. And then the most critical prosecutorial decision, what plea bargain to offer, or whether to offer a plea bargain at all. For example, the defendant gives up his or her right to a trial, and in exchange for that, the prosecution withdraws its notice to seek the death penalty. That's the second most important decision in every capital case. And most capital cases will be resolved with one of those decisions. Either the prosecutor won't seek the death penalty at all, or the prosecutor will seek the death penalty, but ultimately the case will be resolved with a plea bargain, and the defendant will get sentenced usually to life imprisonment without the possibility of parole, but sometime life imprisonment with a possibility of parole, and even in some cases a term of years. In the country today, 94% of all state convictions and 97% of all federal convictions are guilty pleas. So as the Supreme Court has said, this is a system of pleas, not a system of trials. Most criminal cases, from the most garden variety misdemeanor shoplifting case to the death penalty cases, are going to be resolved with plea bargaining. And so, as I said, these are the two most important decisions that are going to be made. And these are made in the complete discretion of the prosecutor. Often they're going to turn on the policies and the politics and the attitude of the prosecutor. The prosecutor means some will decide to resolve a case with a plea bargain, and some will say there's no plea bargain. We're going to trial and we're going to get the death penalty. Or they may make an offer. The prosecutor may say, we're willing to give you life imprisonment or life imprisonment without parole, but the defendant rejects the plea. Even though the prosecutor has decided the case does not have to be a death penalty case, for the plea bargaining system to work, the prosecutor has to go forward with the threat and try and get the death penalty in the case. Just recently was looking at a case out of Alabama in which the prosecutor had offered the defendant 8 to 10 years. The defendant didn't take it. And so the prosecutor got the death penalty as a result of the person's unwillingness to take a plea bargain of 8 to 10 years. Obviously, the death penalty is a way in which to pressure people to enter pleas of guilty, and it usually works. But as in that example, when it doesn't work, it results in a very harsh sentence for somebody who might not have it otherwise. No other country elects prosecutors. That's unique to the United States. This was an ad that Bob Macy ran when he was a long-time district attorney in Oklahoma City. He's running here on his record, 44 people sent to death row, 30,000 felons sent to prison, 15,000 juvenile gang crimes prosecuted, and so forth. He had returned $10 million of bogus checks and fees to innocent victims. So there are a lot of political as well as legal considerations. State prosecutors are elected in judicial districts. They're independent of each other. Unlike in a European system where there's maybe an attorney general who then sets a policy for all the local prosecutors, you can have prosecutors right next door to each other in the United States who have completely different policies with regard to all sorts of things like auto stripping in Manhattan and Brooklyn, but also with regard to the death penalty. So whether or not a person is in one county or another may determine whether that's going to be a death penalty case or not. For example, there was a case in, it's unclear whether it happened in Lexington County in South Carolina or it was Columbia. Lexington sends a lot of people to death row. Almost all white juries, conservative. Columbia, very few, almost no one sent to death row. They actually had to call in surveyors to determine which side of the county line the crime happened on. And if it happened on one side, it was almost definitely going to be a death case, and if it wasn't, if it was on the other side of the line, it would not be prosecuted as a death penalty case. We see this with individual prosecutors. A man named Garvis Davies in Illinois had been sentenced to death. It got reversed. The prosecutor said when it came back that he was not going to seek the death penalty. But then he went out of office and a new prosecutor came in and he decided to seek the death penalty, and he did seek it and obtained it. So just the question of who's in office as prosecutor, and when we see prosecutors' offices change, we often see great changes in their policy with regard to the death penalty. And so, for example, in Houston, when Johnny Holmes and Chuck Rosenthal were the district attorneys, so many people were being sentenced to death that Houston has actually executed more people, over 100 people, at one time more than any state except Texas itself. And then in 2008, Judge Pat Lycos became the district attorney, and all of a sudden the number of death sentences dropped tremendously in Houston. In fact, now more death sentences are imposed in Dallas than are imposed in Houston. But what we see a lot of places is that if a case is prosecuted in Houston, at least during the Johnny Holmes and Chuck Rosenthal era, there's probably going to be a death case. If that same case was prosecuted in Dallas, probably wouldn't be a death case. By the same token, if it was prosecuted in Philadelphia, Lynn Abraham, when she was the district attorney there, went for the death penalty virtually every case where it's possible. But if the case was prosecuted in Pittsburgh, very little likelihood that the death penalty would be imposed because of the prosecutor in that case. So it just raises a question which I leave for you to think about. How important is consistency? Is the fact that different prosecutors in different parts of the state may have different attitudes about the death penalty, different criteria for seeking the death penalty. Is that something that's important, or do we leave that to the prosecutors in each particular place? And do we, by giving one person so much power, is that subject to abuse? Is it subject to race coming into play, particularly when this decision is such a subjective decision and is often made by one person? Well, that's the issue that becomes, that we'll see raised later on when we get to the question of racial discrimination and we start seeing disparities, and we say, who made these decisions, these two most important decisions? Prosecutors are probably less accountable than any other public officials. In a system where we have a lot of checks and balances that limit discretion of other actors in government, that does not apply to prosecutors. A judge cannot tell a prosecutor you can't seek the death penalty in this case. The judge cannot tell the prosecutor not to bring certain charges or to make a certain plea offer. If the prosecutor decides in a death penalty case that he or she wants the death penalty and insists upon filing the notice for it and pursuing it before a jury, and if the jury returns a capital conviction and then makes the case to the jury, if the jury imposes the death penalty, then that's the penalty that's going to be imposed. The judge has no way really to prevent that from happening. And where so much power is exercised is in the plea bargaining process. There's virtually no way that an accused person can prevail on a claim of selective prosecution. There are often cases where it appears that somebody is being prosecuted because of their race or maybe because they exercise their rights to free speech, and yet the Supreme Court has said in a number of cases you can only prevail if you can show that the prosecution was because of that fact. Not merely in spite of it, but you were charged because of your race, or you were sought the death penalty because of your race, or prosecuted because of your exercise of your First Amendment rights to free speech. So what that really has meant is, and the other thing is to prove a prosecution claim, selective prosecution claim, one almost has to have information that's in the possession of the prosecutors, and the courts have pretty much said prosecutors do not have to give that information up. Prosecutors have absolute immunity from prosecution. No matter what they do in a case, as long as it's in the capacity of prosecuting the case, they're immune from being sued for any misconduct that took place. John Thompson's case out of Orleans Parish, Louisiana, is a good example. Thompson came within weeks of being executed, even though there was a lab report that showed that he could not possibly have been the person who committed the crime. It showed that the blood type was a different type than Johnson's type, the blood type of the perpetrator. He brought a lawsuit. He couldn't sue the prosecutors directly, but he brought a lawsuit saying that they hadn't been properly trained, and that because of the lack of training, the parish of New Orleans and the city were liable to him. He won a $14 million verdict at trial, which was upheld on appeal, but then was reversed by the Supreme Court in a case called Connick versus Thompson, which left him absolutely penniless in terms of his recovery in that particular case. So prosecutors, tremendous amount of power, tremendous amount of discretion, and tremendous responsibilities in these cases. Very often the only investigation that's going to be done in a criminal case is going to be done by the law enforcement and the prosecutors. It's just simply the defense is not going to have the resources and the ability to do an investigation. So prosecutors have immense power, and how they use it we'll be seeing as we look at these cases that follow.